A Supreme Court judge has found Northern Territory Police wrongfully arrested and assaulted a man. The Territory Government has been ordered to pay nearly $100,000 in damages to the man Marcellus Majindi. The Police Commissioner is not commenting on the case while he considers whether to appeal. I spoke to Jonathon Hunyor from the North Australian Aboriginal Justice Agency, which acted for Mr Majindi. And a warning, some viewers may find this footage distressing. Jonathon Hunyor, welcome to the program.
Thanks, Louisa.
How did Marcellus Majindi end up in police custody on that day?
Well, the police were called to a disturbance, I guess, in Fanny Bay. They were speaking to Mr Majindi and his de facto partner, and Mr Majindi understood that the police had told him that he should leave, which is what he did. Police then decided to pursue him and arrest him, which the judge in this case, Justice Mildren, found they weren't lawfully entitled to do, and therefore they'd unlawfully arrested him, and they'd done so because they wanted to talk to him.
So he was taken to the watch house. Now we're looking at the police footage from the watch house that evening. Tell us what happened there.
Well, what the judge found happened is that that's where Mr Majindi spits on the officer Miller. And Miller was found to have punched Mr Majindi in the head, and then the police have subdued him. So this is another angle of Mr Majindi being subdued. Unfortunately, you can hear his distress at being quite roughly subdued.
NAJA acted on behalf of Mr Majindi in his bid for compensation. What was the outcome of that?
Well, he was successful in his bid for compensation. The judge awarded him, I think, a total of $102,000 in damages. Mr Majindi was also found liable for the spit on the police officer, so he's required to pay $3,000 to that officer for the spit on him. Will
this case change the way police behave when arresting people, do you think?
Look, we would hope so. We hope it sends a strong message that police will be held accountable for their actions. I think it's important that police are very aware of when they can lawfully arrest someone and when they can deny someone their liberty and take them into custody. And we also hope that it sends a very strong message that nobody's above the law, and that if police do assault people in their care and custody, they'll be held to account.
How unusual is this case?
We do get quite a lot of police complaints. We get a couple of hundred every year from our Catherine and Darwin officers, but they're across a very broad spectrum, from things at the lower end of the scale, such as police speaking rudely to someone or complaints about heavy-handed treatment, to these sorts of things which are at the higher end of unlawful imprisonment and assaults. Of those, the ones at the higher end, like this sort of case, very few ultimately run to court, so it's rare in that case. Often matters will settle, and also our clients are at a significant disadvantage in bringing this sort of case. The police are often good witnesses. Our clients are unfortunately often not good witnesses. They may have poor recall because they were intoxicated at the time and those sorts of things.
The issue of police dealing with people under the influence of alcohol, I mean, it's been 2 decades since the Royal Commission into Aboriginal Deaths in Custody, which recommended that people are taken into custody as a last resort. But in the Territory, police are still locking up people for public drunkenness. I mean, why is this still happening?
Well, we have to recognise that police will often be in a position where they may need to take someone into custody who is severely intoxicated. That's just the reality of the situation. It's always obviously preferable if police can avoid being involved, because that often escalates the situation, and police getting involved as a last resort is a very good starting point. What really is part of the problem is that there are limited options available to police. We don't have enough places in sobering up shelters and in rehabilitation for people to be taken to. But also this case, I think, shows that police need to be very aware of the limitations of their powers. They need to be mindful of not taking people into custody when they shouldn't be.
Potentially critical CCTV vision showing the assault wasn't initially available to your legal team. Why was this the case?
We sought access to all of the CCTV footage initially, and we were provided with some. It was the work of our solicitor working on the case who discovered that we hadn't been provided with all of that footage. There were particular camera angles that we hadn't been given, and we then got that. It turned out to be quite significant because it did show a bit more detail and gave a bit more context to what had happened. We don't know why that's the case, but we think it's quite frankly unacceptable, particularly in a case when the conduct of police was clearly an issue. We think that there's an obligation on police to make sure that they are providing full disclosure.
The 6-month deadline to take disciplinary action against a police officer is now expired. Is it fair that they can still carry on normal work duties?
Well, we think the 6-month time limit is really something that should be changed. I think the public expects that police officers will be accountable for their actions, and if they have engaged in misconduct, and they have in this case been found to have assaulted someone, we think that they should be able to be properly dealt with.
Jonathon, Hunyor, thank you so much for talking with us.
Thanks, Louisa.